So as I said, my name is Barb Van Hoy, and I am a policy analyst with the City of Colorado Springs Community Development Division, and it is my pleasure to welcome you all to our Renter Rights 101 workshop presentation tonight. These events are produced in partnership with Colorado Legal Services, Pikes Peak Library District, the Justice Center, and Colorado Housing Connects. During this workshop, we'll hear from each of them at the beginning to learn a little bit about the housing and legal resources that they each make available in the community, and then followed by an in-depth review of the legal rights of renters in Colorado. But before we dive into that, I wanted to go over a little bit of the presentation format tonight and the controls for captions and questions. So this event is being recorded, and the video will be posted online, hopefully before the end of this week. We will be sharing the slides for the presentation to everyone who is on the registration list for this event. So if you learned about it and joined without signing up at the Justice Center's website, you can go there, find the Renter Rights 101 page and register, even though the event's already happened, and you'll receive by email the slides and a link for the video for the event. Please use, and all of the links we are going to be putting in the chat as well. But again, if you're on the phone, you can sign up and we will send all of this information to you as well. So you can receive that both by signing up at the Justice Center's Renter Rights 101 page. You can also subscribe to the Community Development Division's newsletter, or you can also get this information. We will be posting it on the city's website on the Renter Rights 101 page, again, hopefully later this week. I also want you to know that there is a Colorado Legal Services Renter Rights Guide. It's a PDF that's available on our Renter Rights page at the city's website as well, and you'll be receiving those links. So for the event tonight, all participants are muted, and there are closed captions available in several languages. So as you can see on the slide, if you are tuning in online, you should be able to find these controls both to select captions in different languages, and then also to access the Q&A. So there's a Q&A box. And we can both respond to those questions verbally or in the chat. So if you're viewing through Teams, you can type those questions anytime. But we will also leave some specific time for questions. And so for the call-in participants, you should have the ability to unmute yourself. And so during those question and answer times, you can unmute yourself to ask a question. But other than that, please be sure to keep yourself muted to help keep down the background noise. And the very last thing before we dive into our program is that we would love to know a little bit about you, about who is here. So for those of you who are online, we invite you to use the Q&A box to tell us your name. If you're comfortable, tell us if you're a renter or if you're a landlord. We might also have advocates here, people who are representing organizations, any information like that, we would love to know. And also please share if you have particular concerns, if there's a reason that you came to this tonight, and we can use that to help hopefully answer questions and address your concerns. So the City of Colorado Springs Community Development Division sponsors these events because we are charged with preserving affordable housing, preventing homelessness, and improving struggling neighborhoods. In our role managing the city's HUD grant funds, we are also tasked with furthering fair housing. So providing resources for renters like this event helps us achieve those goals. By ensuring that renters and landlords know their rights and responsibilities, we can help prevent unjust evictions and keep people housed. So that is why we are doing this, and we're excited that you're here. And I am now happy to be introducing some of our co-presenters to tell you about their different resources. So I'm going to start by introducing Deb Hamilton. And Deb is the Strategic Services Librarian with the Pikes Peak Library District. And Deb oversees the law and legal resource collection for the Pikes Peak Library District. And she is going to tell you about, oh, give me just a second. I'm getting the right box slide. Here's Deb. She's going to tell you about the resources available at the library.
Hi, everyone. Let me pull up my screen really quick so we can take a quick look at the library's website. Okay, so as Barb mentioned, I'm the law librarian for Pikes Peak Library District. So our downtown location has a legal research collection that's open and available to the public. All our locations are fully open at this point. We also, though, have a lot of resources on our website, and that's what I really want to highlight today in the brief time I have to talk with you. So I'm just going to start out at our main homepage. The address is ppld.org. And then I'm just going to go here and click into research. And then on this page, I'll scroll down and find law here in the middle. And then when you get on this page, there's a lot of different things here, which we won't go through everything today just due to time, but I want to highlight a few things for you. So here on the left-hand side, we do have some databases that are available, information about legal aid, upcoming legal programs like this one. We also have Family Law Days coming up in July, so if you want to learn more about those programs, you can click through there. And then I'm going to scroll down a little bit. One guide I want to highlight here is eviction information and resources. It's going to have a lot of information about landlord-tenant law, as well as some of the special COVID resources that are available at this time, including those HUD funds that are available from the city. So you can find information about those there in this eviction information and resources guide. But then I just want to highlight a few more things here at the bottom under featured sources. So in a minute, you're going to hear from Britt Kwan at the Justice Center. So they're running weekly legal clinics. There's a link available there that you can learn more about that, as well as get onto their website. Clinton Albert, who will be giving the main presentation this evening, he works for Colorado Legal Services. So if you need to get in touch with them, there's a link for them. Clinton will mention a number of different laws in his presentation that come out of the Colorado Revised Statutes. So anything you see with the abbreviation CRS, if you want to read those in detail, you can go to this website here. And then there's also the Colorado Judicial Branch website here at the bottom. And if you go onto that site and look under self-help and forms, they have a whole section on housing matters. So you can see all the different forms for evictions and foreclosures, or what to do if you feel like you're being unlawfully evicted. So that's another good one to know about. If you have questions about any of these or need help finding things later, you are always welcome to reach out to me. If I don't know the answer, I will point you to someone who can help you. And so there's my contact information. My telephone number is there, or you can click on that button and send an email to me. So those are the quick things I just wanted to point out to you. We'll put the link for this website in the chat. It'll also be in some of the communications that you get after the presentation as well. So thanks again, everyone, for your time, and we'll see you later.
Thank you, Deb. And next, I want to introduce Britt Kwan. And I am going to also share, Britt Kwan is the Executive Director of the Justice Center. And I want to share with you their website. And bear with me as I get this share working. Oh, I see. Okay. So here is the website for the Justice Center. And Britt, are you there? Would you like to tell us a little bit about? Great.
Can you hear me okay?
Yes, thanks.
You can hear me, okay. My name is Britt with the Justice Center. We are a legal aid nonprofit in Colorado Springs. So we provide free legal assistance in a number of areas. I want to start off with call a lawyer. You're going to see all these things in our navigation bar at the top of the page. So call a lawyer is that clinic that Deb mentioned. So every Wednesday night, you can call our main office number between 7 and 9 p.m. And we have lawyers who are volunteering and offering free legal advice. So you essentially can call in, talk to a lawyer one-on-one. It's completely confidential, and that lawyer is going to give you advice on your legal matter. So that's on a weekly basis. We will have clinics in person and maybe some help at the courthouse once the pandemic is kind of on the downward slope. But right now, everything is virtual. The next service I want to highlight is our Find a Lawyer button at the top of our navigation bar. So Find a Lawyer is an opportunity to apply for a free or reduced cost lawyer. It is a financially eligible program, so you have to qualify for services. We get a number of cases. I would say for our pro bono program, the most common types of cases we see are family law cases, landlord-tenant cases, and occasionally bankruptcy or civil cases as well. If you have a criminal case, you can actually apply for a reduced cost lawyer through our programs. This is called the Modest Means Program. So if you make too much to qualify for a public defender, this could be a good option for you. So you can also apply here for a reduced cost criminal lawyer. We do have some priority audiences, victims of domestic violence, seniors, persons with disabilities, veterans, immigrants and refugees, and at-risk tenants. And then the last resource I want to highlight tonight is our tenant toolkit, which is going to talk a lot about similar things that other people are already mentioning tonight, so repeat information. Our tenant toolkit has a few different links on there. One of them is to this renters' rights workshop. A couple of the other ones, we have a few sample forms and documents on that page. We have a link to a lot of videos that have been created on different housing topics. You can also find those by going to our YouTube link at the bottom of our website as well. But those are on a variety of topics. So if you have other questions, you're welcome to go there. And then the last thing on there is a housing ambassador program. So if you're interested in advocating for tenant rights, think about exploring that, or you can send us an email with more questions. And that is all I have. So back to you, Barb.
Thank you, Britt. Thank you for the work of that organization as well. And so next we are going to hear from Patrick Noonan. And Patrick is the Colorado Housing Connect manager, and he's going to talk about the resources that they provide.
Thank you so much, Barb. One thing I hope everybody walks away with after tonight's event is a lot of resources. Boy, it is great to see so many resources coming to bear for people who have housing questions and need help with whatever their housing issue might be. One of those is Colorado Housing Connects, a program of housing nonprofit Brothers Redevelopment. Colorado Housing Connects is a helpline for people to get answers to whatever their housing questions might be. We're going to hear a lot of great information from Clinton tonight about what to do if you have a legal question related to your housing situation. But maybe you don't necessarily have a legal question, you're dealing with something else. You're looking for affordable housing, you're looking for financial assistance to help with rent or mortgage, you're looking for utility assistance, whatever that question might be. Colorado Housing Connects is a free resource for you to access, and we can also help. Maybe you have a family member who needs a ramp or a grab bar in their home. They're have a disability and are looking for some help getting in and around the home. If you are a renter and you're tired of renting, you're tired of putting up with some of these legal challenges, we also help a lot of people transition from renting into home ownership and connect them with a lot of the great resources in the community to do so. So whatever your housing question might be, we hope you'll reach out to Colorado Housing Connects, and we'll make sure everybody has the phone number and website for it at the end of the day. A lot of great information coming tonight. I'm excited to hear it myself, and I thank you for the opportunity to share a little bit about what we do.
Thank you so much, Patrick. I really appreciate that. And we will also be adding a lot of these links in the chat pretty soon. So next, I am excited to introduce our housing attorney with Colorado Legal Services. Clinton Albert is housing attorney with Colorado Legal Services, where he has served for 3 years. And at Colorado Legal Services, his caseload is made up solely of landlord-tenant matters and covers a broad range of legal issues within that area. He's been presenting the renter rights series since about 2008, and we are really excited to have him here today to share with you. Thank you, Clinton. Oops, hold on, let me get the full presentation sharing. There we go.
All right.
All right, take it away, Clinton. Thanks.
All right. Well, good evening, everybody. My name's Clinton Albert. I'm an attorney with Colorado Legal Services. Tonight, we're going to be covering a broad range of topics related to a lot of common issues that tenants and landlords will face. But keep in mind that this is going to be for informational purposes only. Housing issues and cases require a thoughtful analysis of the facts and the law that apply in your case. Also, as we're still in the pandemic itself, the COVID protections have changed on a near monthly basis, and that alone would require a case-by-case analysis. So if you are a low income or a senior citizen and are facing a housing issue, you may contact Colorado Legal Services at the number listed there. I do have in person, I would recommend the phone. We are still not open for walk-ins at this time, but that may change in the future. But to start off this presentation this evening, I wanted to discuss what the protections are for tenants as it relates to COVID-19. At the state level, at Colorado, we have the most recent executive order, which is D 2021-088, and this re-implemented the 30-day demand for non-payment. It was signed on April 20th. It was in effect for 30 days, so it expires tomorrow. Landlords are required to provide tenants with a 30-day demand for payment before they're able to initiate any kind of suit. Some past executive orders dating back to last year. What we will do is I will forward the slides so that you guys can have a copy of them, but the links to all the prior executive orders are here as well. At the federal level, there is still the CDC temporary halt in residential evictions to prevent the further spread of COVID-19, or shorthand, the eviction moratorium. It's extended through June 30th, 2021. And what it states is that landlords, owners of residential property, or other persons shall not evict any covered person. The reason I included this slide is that recently a judge in Washington, D.C., sorry, I'm struggling for the name of the case caption. It's the Alabama Association of Realtors versus the United States Department of Human Health and Services. And in that case, the judge did vacate the CDC order. However, the HHS is appealing that order. And while that appeal is still pending, the CDC moratorium is still in effect. So if you have heard that the CDC moratorium was overturned by a judge, that is technically accurate. However, it is still in effect while the appeal is pending. So what does the CDC eviction moratorium say? Well, as I already indicated, it prevents the eviction of a covered person. And a covered person is any tenant, lessee, or resident of a residential property who provides to their landlord a declaration under penalty of perjury, indicating that this is the, if you've heard anybody talk about a CDC declaration, that's where we're at this point. And what the declaration states, its contents, are that the individual has used their best efforts to obtain all available government assistance for rent or housing, that they meet the financial requirements of the CDC moratorium, that they're unable to make their full rent or housing payment due to a substantial loss of household income, hours, wages, layoff, or extraordinary out-of-pocket medical expenses, that they're using their best efforts to make partial payments that are as close to the full payment as their circumstances may permit, taking into account any other non-discretionary expenses, and that an eviction would likely render the individual homeless or move into close quarters in a new congregate or shared living setting, because that individual has no other housing options. There's a link to the CDC form, and as it relates to the declaration itself, there have been a number of different declarations. Even though it states that there's an expiration date in the upper right-hand corner, it's my position that as long as the law is still valid, which it currently is while the appeal is pending, the declaration is still valid. So does the moratorium prevent all evictions? No. Eviction is, here's the list of things that evictions can still proceed for. Let me go back here. The better way to think of it is the only type of eviction that the moratorium protects against is an eviction for non-payment of rent. The moratorium does not waive rent payment. So after either on July 1st, or if the appeal is denied in the appellate courts right at the moment, then tenants are still going to be required to pay that full amount, and landlords are able to serve a demand for that full amount at that time. There will also may be other ramifications in that area as well. A full text of the original eviction moratorium order is there. The best copy is the one from back in September of 2020, because the extensions since that time have just kind of been one or two sentences to the effect of we're extending it, we're extending it. So there's really not any, there have not been any significant updates to it. And that's the most recent copy, the most recent extension. So before we move into kind of broader things, I'm just going to check the chat real quick to see if there are any questions related to the pandemic protections. All right. So before you move, as a tenant, before you're moving into your new home, what are some things that you want to keep in mind? First of all, before you even get to that moving stage, this is going to be based in this part is the application process. And that's that in beginning this year, Colorado has banned income discrimination in housing. What does this mean? It means that a landlord can't deny a possible tenant based on the source of that tenant's income. And a source of income is defined as any lawful and verifiable source of money paid directly or indirectly or on behalf of a person, including a lawful profession or occupation, or income or rental payments derived from any governmental or private assistance, grant, or loan program. There's a link to the new unfair housing practices law, which does include income discrimination. Significantly, if you are a participant in the housing choice voucher program, this means that those ads that used to say no Section 8, no vouchers, those aren't valid ads anymore. All right, so landlords cannot discriminate based upon using a voucher or where the lawful income is coming from. Keep in mind to put everything in writing as you're going through this process. Conversations are hard to recall, and they're even tougher to prove if it's not in writing. The lease that you enter into is a contract between you and your landlord. In Colorado, oral leases are valid, but they are more difficult to prove. If your landlord, if you work out an agreement where at the beginning you say, well, it's going to be 6 months, but you have nothing to really back that up, there's a presumption that it's going to be a month-to-month lease. And you cannot have a lifetime lease because an oral contract can only be for up to 2 years. So even if you enter into an oral lease, you can still go back and memorialize it in writing, which I would advise you do if you find yourself in that position. Another pre-lease issue is going to be in the application itself. Landlords are not able to charge an application fee unless the landlord's using that entire amount to cover the costs in processing the applicant's application. Costs are either going to be the actual expenses taken in processing the application, or the average expense that a landlord has when it processes multiple applicants. Landlords are not able to charge a different amount to different applicants, and they must provide the applicant with a disclosure for how much it's going to cost to process the application and provide a receipt for the application fee. If there are any remaining funds, then the landlord has to make good faith effort to return those amounts to the applicant. In the application process itself, the rental history and the credit history is somewhat limited as to what a potential landlord can consider if they're looking at your application. That is really limited to the past 7 years of rental or credit history. If you had a bankruptcy or an eviction from 8 years ago, that cannot be used to deny you in a residence today. What about criminal history? This is another issue that comes up on a lot of applications. As far as arrest records, that can never be held against you. So if you have 40 arrests and 0 convictions, then that cannot be used as a reason to deny you a residence if you're applying for it. If you have a conviction that is older than 5 years, that also cannot be used against you, except if it's generally related to methamphetamine. I say generally, there may be one exception, but for the most part, methamphetamine related offenses are going to be grounds to deny an application. Any conviction or offense that requires a person to register as a sex offender pursuant to the Colorado Revised Statute, homicide related offenses, and stalking. Now, if those limited convictions, those can be held against you as a potential tenant for any number of years. They are not time barred. So if you have a 10-year-old stalking case, that can be used against you. If you have a 20-year-old methamphetamine production case, that also can be used against you. Now, what happens if you apply and your application is denied? Well, if you're a landlord, you have to provide that applicant with a written notice of the denial, and as a tenant, you have a right to that denial in writing. That written notice, that written denial, it has to say the reasons that the landlord is denying your application. And landlords, you have to make a good faith effort to provide this to the applicant within 20 calendar days of the decision to deny the application. Landlords, if you don't follow the law, there are penalties. And tenants, if the landlord is not following, if this potential landlord did not follow the law, you do have recourse in the courts. You can seek 3 times the amount of the application fee plus court costs and reasonable attorney fees if a potential landlord did not follow the law in regards to the Rental Application Fairness Act. You must first give the landlord notice of your intention to file the action at least 7 days before filing the action. As a landlord, you have the ability to cure that. For example, if you had failed to provide somebody with the written notice of denial, you have 7 days to provide that to them. And if you're a tenant, keep in mind that if you just speak to someone about a residence but don't actually apply, you don't have that right to the written notice of denial. Now, if you were applying for a residence and denied, and you bring an action against that landlord, but a court finds that it's a meritless claim, then you will be liable for the landlord's court costs and attorney fees. And those are the authority down there. That's the Colorado Revised Statutes, section 3812, 901 through 905. Now, once we get through the application process, if you're approved, the next step is going to be getting that lease and signing it. But please, I cannot stress this enough, don't just go through the signature blocks, initial and sign. Take the time to read it. Whether it's 2 pages or 40 pages, this is a binding contract that you are about to enter into, and you are about to commit yourself to a lot of financial responsibility in this document. So make sure to take the time to know what you're signing. What's the length of the lease? Are we talking about a month to month? Is this a year long, a 2 year long? What are the terms? What happens at the end of that first term? Is there a rollover provision? Is that rollover provision mandatory? What about fees for late rent, any kind of late utility payments, landscaping fees, pet fees? What about responsibilities for upkeep and maintenance? Not so much warranty of habitability issues, but if you're renting a single family residence or some kind of duplex or triplex with a yard, are you responsible for that outdoor maintenance, or does that fall to your landlord? Other sections to pay attention to is a notice related section, and that's where you're looking to see, is this tenancy an exempt residential agreement? Also, as it relates to the warranty of habitability, what appliances are included in the lease, and what's the email address for your landlord for you to provide electronic notice delivery? So I'd refer to exempt residential agreement in the past slide. What does that mean? That is a specific kind of tenancy. It only applies to single family homes, so not an apartment or a condominium. And the home must be leased by a landlord who owns 5 or fewer single family rental homes. And notices provided in the lease that the 10-day notice period does not apply to this tenancy. So that means that oral leases can never be an exempt residential lease because the notice has to be provided in the written lease that this is an exempt residential lease. So what does this all mean? Exempt residential agreements provide a tenant with 5 days to cure a non-payment of rent instead of 10 days. What are unenforceable lease provisions? Just things that even if this is in your lease, a court's not going to uphold this. A court is not going to uphold a lease provision that waives, as a tenant, your right to the return of the security deposit. That's not a guarantee that you receive your security deposit. You just cannot waive your right to the possible return of it. You cannot waive the warranty of habitability, barring a separate agreement, which we'll touch on a little bit later in this presentation. You can't waive the covenant of quiet enjoyment or a 5 or 10 day demand for unpaid rent. You can also not waive the court process for eviction cases. Excuse me. So once you've signed everything, get a copy of your lease. You should get a copy for your own records if there's ever a dispute. Also, the law requires that your landlord provide you with a copy within 7 days of you signing your lease. What about receipts for rent payments or security deposit? Excuse me. Sorry, hair in my throat. If you pay in person your rent or your security deposit with a cash or money order, you have the right to a receipt immediately. If you pay by cash or money order and request a receipt, your landlord has 7 days to give you a receipt. I would strongly recommend that if you're paying with cash or money order, to always request and receive a receipt and to keep those secured, preferably with your lease. That way, if there's ever an issue, you know right where to go to retrieve that documentation. As you're moving in, take pictures. Take the time before the place becomes cluttered with boxes and everything, and everything's starting to get unpacked and moved in. Document the condition of the residence. It shows what the condition is when you're first moving in, whether it's damaged or undamaged. Document what it looks like. At the conclusion of your tenancy, this documentation may prove to be crucial for any kind of security deposit dispute. Now, if possible, and go through do a walkthrough. Now, a lot of times you're not going to be able to do this in person with your landlord, but if you get that walkthrough checklist sheet, go through and inspect everything and make sure to turn that in a timely fashion. That way you have that documentation. You want to be able to identify pre-existing damage. That way both you and your landlord are entering into this lease with the same understanding of what the condition of the residence is. Be critical, but don't be unreasonable. You're not being a bother by pointing out existing damage. This is a business relationship between you and your landlord where you have contracted to rent this property. And if there's damage, you want to make sure that you're not held responsible for it. Other things to pay attention to in the lease are going to be any rules and regulations. These are going to be additional conditions of your tenancy. And if it's not explicit, if there's not like a sheet of here are the additional rules and regulations, but there's reference to it, make sure to ask for a copy of that as well. You may receive one with your lease, but if it's alleged a rule or regulation is being broken, then there's a risk of an eviction case. Some common rules may be quiet hours, if there's a grievance procedure for any resident disputes, landscaping rules, picking up after your pet rules, smoking, all of those kind of things you'll be able to find in rules or addendums. So just make sure that you're paying attention to what the actual rules of your tenancy are. Moving on to the warranty of habitability. This is the promise that your residence is fit for you to live in as a human. There are a list of things that specifically in the law must be present. That resource that had been referenced earlier with the city's renter rights site, there is a packet there of written materials, and you can find that list in the packet. Electronic notice, and this is really in the context of the warranty of habitability. A work order is not notice. So what does make up electronic notice? And when I'm talking about this, what I'm referring to is how you're putting your landlord on notice that your residence is uninhabitable. You're able to provide it in writing, in person, or through the mail, but you also have the right to provide an electronic notice. What that is by email, by portal system, or some kind of communication system that's available to both your landlord and you. And if you send an electronic notice, you must send it to only that email address, phone number, or portal that's specified by the landlord in the rental agreement, going back to reviewing the terms of your lease. If your rental agreement says send it to this email address, and then you send a text message, that's not going to be notice. If your lease doesn't say where to send an electronic notice, then you can send an electronic notice with your landlord in a manner that your landlord has previously used to communicate with you. So if there's not an email address listed or a portal system, and you and your landlord have texted, that means you're able to provide that notice via text message. So if your lease is silent, then the practice in your landlord-tenant relationship is going to control, meaning if your landlord texts, then you can text. If your landlord emails, you can email. You must retain sufficient proof of delivery of the electronic notice. So what are the conditions that are subject to the warranty of habitability? There must be sufficient waterproofing and weather protection of your roof, walls, doors, and windows. You have to have plumbing and gas that's in good working order. Running water, reasonable amounts of hot water, proper fixtures and connections to sewage disposal system. The functioning heating facilities must be in good working order and in compliance with the law. The electrical, lighting, and wiring and equipment must also be in good working order and in compliance with the law. The common areas under control of the landlord must be kept reasonably clean. There must be an appropriate extermination in response to any infestation. Bed bugs have a more specific process that we'll touch on in a little bit. Why don't we start now? So if there are bed bugs, as a tenant, you have to promptly notify your landlord via written or electronic notice when you know or reasonably suspect the dwelling unit contains bed bugs. Landlords, once you get that notice, you are on the clock. Within the following 96 hours, you have to first provide the tenant with 48 hours notice of your intent to enter the dwelling, and you also have to obtain an inspection by a qualified inspector. You may enter the first dwelling unit or any contiguous unit for the purpose of inspection. If the inspection confirms the presence of bed bugs in the original unit, then all contiguous units must be inspected as well, as promptly as is reasonably practical. And landlords, you are responsible for all costs associated with an inspection for and treatment of bed bugs. After that inspection, landlords, you have to provide your tenants with written notice within 2 business days whether the unit contains bed bugs or not. If the inspector determines that neither the unit nor any contiguous unit is positive for bed bugs, then as a landlord, your notice must inform the tenant that if their concerns remain, that they may contact the local health department. If the inspector does, however, confirm bed bugs, then the inspector has to provide a report to the landlord within 24 hours. And then as a landlord, once that inspection's done, landlords, you have 5 business days to start reasonable measures to effectively treat the bed bug presence. This is not something you get to put off for a week or 2. All right, you've got 5 business days. Now, as a tenant, you have to do more than just report it. You have to comply with any reasonable measures to permit the inspection of your residence and also the treatment of the residents for bed bugs. You, as a tenant, are responsible for all costs associated with preparing the dwelling for inspection and treatment. So if to get it inspected, you have to bag up clothing or put dishes into tubs, it's going to be your responsibility to get those bags and those tubs. That's not going to be your landlord's responsibility. Now, if you knowingly and unreasonably fail to comply with the inspection and treatment requirements, you may be liable for the cost of those treatments and also any contiguous dwelling units treatment as well, if the need for treatment arises from your non-compliance. As a landlord, if you know that or reasonably suspect that a unit has bed bugs, you can't rent it. And if you have an applicant that asks, you have to disclose to that person whether to your knowledge the unit contained bed bugs within the last 8 months or disclose the last date the unit was inspected for and found to be free of bed bugs. Landlords, if you don't comply with the rules and procedures related to bed bug infestations, you're going to be responsible for actual damages. You may also apply for injunctive relief against a tenant who refuses to provide reasonable access to the dwelling or fails to comply with reasonable request for inspection or treatment. And if a court finds that either that a tenant has unreasonably failed to comply, they may issue an order granting access to the dwelling, the right to inspect and treat, and requiring tenants to comply with specific inspection and treatment measures or assessing the costs and damages related to the tenant's noncompliance. Jumping back to the warranty of habitability conditions, your residents must also have an adequate amount of outside receptacles for garbage, must have working floors, stairways, and railings, the locks on exterior doors, and security devices on windows that open. And it also must be in compliance with all applicable building, health, and housing and health codes, which materially interfere with your life, health, or safety. Another condition is mold, which is microscopic organisms or fungi that can grow in damp conditions in the interior of a building. And mold renders a residence uninhabitable when mold that is associated with dampness or there's any other condition causing the residence to be damp, which, if not remedied, would materially interfere with the health or safety of the tenant, excluding the presence of mold that is minor and found on surfaces that can accumulate moisture as part of their proper functioning or intended use. If you're hopping out of the bathroom after a nice steam, keep the door open, all right? Because if you keep all that kind of steam trapped in the bathroom, you're going to be looking at mold after an extended period of time there. I had also mentioned appliances earlier in one of the first sections about reviewing the lease, but certain appliances are protected by the warranty of habitability. Refrigerators, range stoves, or ovens, which are included within the residence for the use of the tenant pursuant to the lease or any other agreement between the landlord and the tenant. The warranty of habitability only applies to the appliances specifically listed in a written agreement or otherwise actually provided by your landlord at the beginning of your tenancy. If you make a demand if you make a warranty of habitability demand based upon appliances and your landlord replaces the appliance, there is a presumption that the replacement appliance is not installed in retaliation, so long as it has substantially the same features as the original appliance. I like to think of this section as if there's one of those smart refrigerators with an LCD screen in it, and the fridge breaks, and a fridge without a TV screen in it is the replacement fridge. That is not retaliatory. However, if a fridge breaks and you get a Coleman cooler with a bag of ice, that is going to be retaliatory. So also, your residence must not be in a condition that materially interferes with your life, health, or safety. This is a subjective standard that's going to be based on a tenant's individual characteristics. So this is kind of a larger net just to make sure that there are no conditions which would put a tenant's health or safety or life, for that matter, at risk. If this is the type of condition that's being alleged in that warranty of habitability notice, it does alter a landlord's response timeline. So I've been talking about notices and timelines. So at what point does a landlord breach the warranty of habitability? And before I get into this section, let me just check the chat real quick. So I have a question on how do landlords respond to a request to change a contract before signing? Do they just reject the applicant? It's possible. At that point, you would be negotiating a contract, and they don't have to accept the proposed counteroffer. And then I also have, will bad credit, no credit affect a housing voucher? No, it should not. However, there is quite a lengthy wait time for the voucher wait list. If you want to inquire into that further, I would recommend that you contact the Colorado Springs Housing Authority. So jumping back to when does a landlord breach the warranty of habitability? The residence is uninhabitable. Uninhabitable will be one of, as described by statute, that list of slides that we just went through, or it's in a condition that materially interferes with a tenant's life, health, or safety, and the landlord has received reasonably complete written or electronic notice of the condition and failed to commence remedial action by employing reasonable efforts within the required times. So what are those required times? There's the timelines. There are different ones for materially interfere with life, health, or safety, or that it is uninhabitable by statutes, and lastly, mold. Life, health, or safety. As a landlord, you have 24 hours to commence remedial action. If it's for one of the listed conditions that we went through, 96 hours to commence remedial action. But that only applies if you as a tenant have included permission for the landlord or landlord's agents to enter the premises. One way to solve that is just to include that permission in your notice itself. What about mold? Mold has more timelines in it, or more kind of little check marks that need to be accomplished in certain sets of time. As a landlord, within 96 hours after receiving a notice from your tenant of mold rendering the residence uninhabitable, you have to install a containment stopping active sources of water to the mold, install a high efficiency particulate air filtration device to reduce exposure. You have to maintain that containment until the following actions are executed. That is that within a reasonable amount of time, you must establish appropriate protections for workers and occupants, eliminate or limit moisture sources, dry all material, decontaminate or remove damaged materials as appropriate, evaluate whether the premises has been successfully remediated, and reassemble the premises to control sources of moisture and nutrients to limit any recurrence. So as a landlord, if you receive a notice of a warranty of habitability issue, and as a tenant, if you send one, landlords, you have to respond in writing, and tenants, yes, you have absolutely a right to get some kind of response in writing. Within 24 hours of receiving notice of a warranty of habitability issue, regardless of what the issue is, whether it's mold, a statutory condition, or life, health, or safety, landlords, you have to respond. And in that response, you must state what your intention is for remedying the condition, give an estimate on when the remediation will start, and an estimate of when it will finish. So you have to say how you're going to fix it, when you're going to start fixing it, and how long it's going to take. What about an alternate residence? If your home is uninhabitable, is there ever a case where your landlord's going to have to pay for an alternate residence? Yes. If the residence is in a condition that materially interferes with your life, health, or safety, and you make such a request, then yes, your landlord has to provide either a comparable dwelling unit as selected by your landlord at no cost to you, or a hotel room as selected by your landlord at no cost to you. Landlords are not responsible for any other costs that arise after that relocation period. A tenant is still responsible for rent per the terms of the lease during this time. And again, this only applies to material interference with life, health, or safety. So what can a tenant do? What happens if your landlord breaches the warranty of habitability? So after you've provided proper notice and you haven't received any kind of response, there hasn't been any remedial action, you can terminate the lease. You can obtain injunctive relief in either county court or district court. You can defend against an action for non-payment of rent, so long as you began withholding your rent after the breach of the warranty of habitability. And there are other monetary options as well, to include offsetting repairs. So withholding rent. If, as a tenant, your landlord has breached the warranty of habitability, you do have the option to withhold rent. Your landlord's going to likely take you to court, claiming that you have not paid your rent. If that does happen, you're going to have to pay into the court the amount of rent that you withheld in order to be able to use that as a defense in the eviction case. If there is a problem with the notice of the warranty of habitability, then you will not have a defense against non-payment. So prior to withholding rent, I would recommend that you seek legal advice prior to doing so. And keep in mind that you can bring a claim for the breach of the warranty of habitability outside of an eviction case. You're also able to deduct the cost of repairs from your rent. This is an incredibly specific process. It does not apply to everyone. It cannot deduct for certain lease issues. I would seek legal advice before taking this action, because once you get an estimate from a certified or qualified person to do the work, you have to send that to your landlord, and then your landlord has the opportunity to then seek out their own estimates and then hire that person. If you make bad faith deductions, you will risk an eviction. So if you wrongfully deduct rent, then your landlord will get a money judgment in that amount withheld. And as a tenant, you will also likely be evicted for non-payment unless there is some kind of other defense there. If it's a bad faith deduction, then it is an automatic eviction and a money judgment for 2 times the amount that was withheld for deducting the cost of repairs. So again, this is a very specific process, and if it is not done correctly, there are drastic consequences. So I would strongly recommend seeking legal advice before deducting the cost of repairs from your rent. Are there exceptions to the warranty of habitability? Yes. This is what was indicated in the beginning. So in a lease, as a tenant, if you have some special skills, then you and your landlord are able to sign a separate agreement that is supported by adequate consideration, where you take on the responsibility for some kind of condition in the home. You must have the skills to perform the work. If you're a electrician, then probably aren't able to do the plumbing work unless you're also a plumber, but that's kind of what I'm referencing when I'm saying that tenant must have the skills to perform the work, not just that you've done it in the past, but this is something that you have the skill and the knowledge to do. If you're unsure about whether this applies to you, again, please seek legal advice. Other resources for warranty of habitability issues also include the Department of Health, and just generally speaking, other resources are going to include your neighborhood services office in the city, and also your community development office for anybody outside of city limits. A little bit on code enforcement. Code enforcement only has the authority to enforce the minimum housing standards of the city code, does not have the ability to enforce the warranty of habitability. That is not their jurisdiction. Some issues are not included in the city code that are in the warranty of habitability, like mold. You can call both code enforcement and also provide your landlord with a warranty of habitability notice. But just one way to think about it is the warranty of habitability is for court, and code enforcement is about city code. Before moving into security deposits, just going to check the chat for any questions. If a lease is based on knowingly inaccurate information, is it still valid? It depends on it, possibly. It depends on what we're talking about. And that's, as we're getting more fact specific there, that is going to have to be a question to look at in more depth and detail. In regards to credit and a voucher, it's possible that could be the case, but again, on that kind of situation, it's going to require a little bit more investigation. So I would recommend that you apply for some kind of follow-up services. And seeing if I don't believe I missed any questions, so let's move into the security deposit section here. And one thing just to keep in mind as we're moving through this is the security deposit is, if you are a landlord listening to this, the security deposit is not your money. It is not. You should be keeping it in a separate account. You shouldn't be commingling those funds. Your landlord can only keep your security deposit for any damage beyond normal wear and tear, non-payment of rent, the abandonment of the residence, non-payment of any utilities, repair work, or cleaning work that was contracted by you as a tenant. So what is normal wear and tear? That's the usual deterioration which occurs when living in a residence. What is not? Careless or intentional destruction of property, a hole in the wall, cigarette burns in a carpet. So in the context of the security deposit, what should you do when you move out? Clean the residence, wipe down the baseboards, clean the oven, take the time to go through the kitchen appliances to clean those out as well. Those are time intensive. So if you find yourself looking at a security deposit withholding and you're seeing 3 hours for cleaning a kitchen, it may be related to any kind of oven cleaning. So I would recommend doing that as well. Do another walkthrough, just like at the beginning of your tenancy, and take more pictures. Even if you didn't do a walkthrough at the beginning, still take pictures at the end. Also make sure to return the keys to your landlord and provide them with a forwarding address on where you can receive mail. Now, once this has occurred, how long does your landlord have to return your deposit and/or give you some kind of statement of deductions? That's up to 30 days. Unless that time period is extended in your lease, then that can be up to 60 days. Now, if your landlord does not return your deposit, you're going to have to send a demand letter. I'd recommend sending it via certified mail and to keep a copy of the letter. Certified or anything that really shows the tracking on it as to when it was delivered. These are just some sample letters. There's really not any kind of required form for a security deposit demand. Just stating if you're contesting any kind of withholding, I would certainly advise stating the reasons for why you're contesting the withholding. Also, if you didn't receive anything, then you would just send that to him. As you can see, each letter references 7 days in them. And we'll get to that in a little bit, but your landlord your former landlord has 7 days to cure any wrongful withholding. So your landlord may also only refund part of your deposit. Beware of a restrictive endorsement. When I'm referencing that, something that says acceptance of this constitutes a full and final resolution of this matter. So let's say you've sent the 30 to 60 days has passed. You've sent your demand letter. You've waited 7 days and you haven't gotten any kind of response. What's going to be the next step? That's going to be to initiate a small claims action or an action in county court if the amount is under $7,500. Small claims court is limited to cases under $7,500. County court is for cases under $25,000. You can, as a tenant, you can seek treble damages or 3 times the amount for a wrongfully withheld security deposit if you file your case within 1 year of the wrongful withholding, and a willful withholding is found by the court. What is a willful withholding? That is when the landlord deliberately fails to return the security deposit during the additional 7-day period. The retention is logically willful under the security deposit section. What about early lease termination? Since we're kind of at the end of the tenancy here, what happens if something changes in your life circumstances and you're looking to terminate your lease early? Are you able to do that? Sometimes the language of the lease allows that to occur. If there's a breach of the warranty of habitability as a tenant, one of your remedies is to terminate the lease. There are also you're also able to terminate your lease early if you are a victim of domestic violence, domestic abuse, stalking, and/or unlawful sexual behavior. Military orders, an act of God such as lightning strike or flooding, so long as it was not caused by your negligence. Also, you're able to terminate your lease if there are multiple warranty of habitability breaches within at least 2 times within a 6-month period, and the condition is appliance related. It does have to be the same condition. So if your hot water goes out and your landlord fixes it and then it goes out again, you are able to terminate your lease with a 14-day notice to your landlord. Moving into the Mobile Home Park Act, before we do so, just going to check the questions. In relation to the water question, that is a little, it's possible. Would need to look at the case a little bit more then. But would DV of crime victim be responsible for repairs? It's going to depend on the parties to the lease. So no, if that it depends. It can be no, but it could be yes. It's just going to depend on the situation, since there are multiple situations there. So I would recommend, given that that's a little bit fact-based, for you to apply for additional services or just some additional advice on the matter. All right, moving into the Mobile Home Park Act. There are additional rights for tenants in mobile home parks who own their homes, not just living in the park, but you also have to own the home and live in the park. You are entitled to a written lease or rental agreement, and a termination of your tenancy must be for cause. That's opposed to ending the tenancy with just a notice to quit for no reason, or you don't have to have any kind of cause. There's also no cure period. We will get to that in the eviction section coming up here. So what constitutes cause for termination? There's a slew of different reasons that the home is not in compliance with the local ordinances or laws or regulations relating to mobile homes and home lots, not following the park's rules and regulations. The park is condemned or it changes use. You, as a tenant, you provide false or misleading statements on your application. You, your guests, or your friends' conduct unreasonably endangers the life of a person in the park. The conduct damages or destroys the property of a person in the park in a willful, wanton, or malicious manner. The conduct constitutes a felony offense, or the conduct was the basis for an action that declared the home a Class 1 public nuisance. Class 1 public nuisance, betting parlors, brothels, and illegal kind of, I guess, bong shops. There's a number of different kind of public nuisance categories, but they are specific. So not just that it's annoying, or you're saying that's not a subjective standard, that's a legal standard. So when can the park change its own rules and regulations? If as an owner you give your permission, they can be changed immediately. However, if you do not give your permission, then those rules and regulations will take effect 60 days after notice is provided. Some updates to the Mobile Home Park Act, and that is that with a notice to quit or a demand for compliance as the homeowner, you are given a 90-day cure period for any demand for compliance, and you're also given a 90 days on a notice to quit. In that 90-day period, that's to either move or sell the home. For security deposits, parks are not able to charge a greater amount than 1 month rent for a security deposits. There's also an expansion of homeowner privacy rights by requiring parks to provide notice for entry onto the lot or into the home itself. There are additional changes that we don't have time for to get in this evening, but if you do have a question, I would, again, I know I sound like a broken record on this point, but given the fact-specific nature of these cases, I would strongly recommend that you apply for additional services. There's also the Mobile Home Park Dispute Resolution Act, and this is an administrative process that is before an eviction case is taking place in court. Sometimes it doesn't necessarily have to be, but it can be. I'm just checking time here. So any party, whether that's park management or a tenant, can file a complaint with the Division of Housing. The division will investigate the complaint, facilitate negotiations between the parties. And if the parties are unable to come to an agreement, the division shall make a written determination of whether there was a violation, and that determination must state the basis for the determination, the violation, the necessary actions to cure, the time to cure, the penalties for not taking the necessary action, and the process for contesting the determination, and penalties by means of an administrative hearing. If there is not a violation, then they have to state the basis for the decision and a process for contesting the determination. If there is a violation, then the party has 7 days to comply with the notice of that violation. Failure to do so gives the Division of Housing the authority to impose financial penalties for each day that the party fails to come into compliance. The Division of Housing can also issue a cease and desist order to stop an unlawful practice, can order a party to take actions to include but not limited to refunding monies paid, filing documents that correct a violation, or taking action to correct a violation. Parties can appeal a decision from the division by requesting a hearing before an administrative law judge. The judge is going to hear testimony and receive evidence to decide whether the division's decision is supported by a preponderance of the evidence, meaning it's more likely than not that the division decided the case correctly. The judge is going to enter an order within 30 days after the hearing and send copies to the parties. So that's just very broad strokes of the mobile home dispute resolution process. All right, thank you, Deb. So moving on to eviction cases themselves, this is the forcible entry and detainer is eviction. So landlords must use the court process. They cannot resort to self-help. They can't change the locks, remove the doors, things like that. They have to go to court first. It lists the statutes list reasons that a landlord can start an eviction. I've listed those out in more detail in information and materials that are available online. The first step is receiving a notice to quit or some kind of demand for compliance. There's not an official form that needs to be used for these. These are just some state forms that do exist, but they do not have to, your landlord does not have to use these forms. There's, again, no specific language or state form required for the notice. So for a notice to quit, now this is a document which terminates the tenancy at the end of the tenancy period. All it has to do is describe the property, provide the date of the termination of the tenancy. It has to be signed by the landlord, and it must be served by the statutory deadlines. So that means that a month-to-month tenancy requires 21 days of notice before the end of the month in order for a landlord to terminate a month-to-month tenancy. These notices to quits do not have any right to cure because there's not any kind of violation being claimed here, just that the tenancy is going to be ending. Now, for a demand for compliance, if we go back a slide, that's going to be this document over. You can see it's captioned demand for compliance. If it is a demand for payment, and it was, again, there in the last year, there have been significant periods of time, whereas a tenant, you were entitled to 30 days to be able to cure that non-payment. If it is something other than non-payment of rent, if it's you have too many people living there, there's smoking in the unit, there's an unauthorized pet, then you have 10 days to cure that issue. Once the time period ends on the notice or demand, that next day, your landlord does have the ability to take you to court. And the first step in the court side of things is going to be serving you with a summons and complaint. Service is either going to be by personal service or by posting. Personal service is where it is handed to you in person, and by posting is when it is taped to your door. If you're served by posting, your landlord can only receive a judgment for possession and not get any kind of judgment for unpaid rent. However, if you appear on the return date or file an answer, then you do waive personal service. Now, an answer, that's your legal defenses in response to the complaint. The complaint is your landlord stating, these are the reasons that I have this right to legal relief, and your answer is stating, these are the reasons that my landlord does not have that right. There are a number of defenses. We really don't have the time to get into them all this evening, and given that that really any defense available in contract law may be available to you in an eviction case, it's going to be a case-by-case determination on what defenses, if any, may be available to you if you are facing an eviction. One defense to keep in mind related to the warranty of habitability is if your landlord retaliates against you for making a good faith complaint to your landlord or a government agency, such as code enforcement, regarding the warranty of habitability or organizing and becoming a member of a tenants association or similar organization, you can assert the breach of the warranty of habitability as a defense to a non-monetary eviction. So if your landlord gives you a notice to quit after you've in retaliation for making a good faith complaint to your landlord regarding the uninhabitability of your residence, then that would be a defense against that notice to quit. Make sure now this doesn't really apply at the moment because the courthouse, at least here in El Paso County, is still closed to in-person appearances. However, I do always include this slide to just kind of emphasize the importance of the return date. At a certain time, the courthouse will reopen. So the return date is not the day to figure out what to do on the case. That's the day that there either needs to be an answer or a settlement filed in the case. So again, most courts are currently operating by phone or virtual hearings for cases. Make sure to check local courts' current operating procedures. Here in El Paso County, it is still virtual hearings and non-appearance return days. But in Fremont County, it's a bit of a mix where some folks are able to appear virtually, on the phone, or in person. So just make sure that depending on where you live, you're consulting your local court's website about what their current status is for in-person appearances. Now, once an answer is filed, going back to the answer, the trial is going to be scheduled by law. It should be scheduled within 5 days. Sometimes calendars don't accommodate that, so it is pushed out a little bit further. If the court rules against you as a tenant and rules in favor of your landlord, they are going to issue what's called a judgment for possession. That's the legal term for eviction. Now, 2 days later, what they do is they issue the writ of restitution. This right here is the document that allows the sheriff to come and remove you from the property and return possession to your landlord. Currently, now this is a good section to discuss the CDC eviction moratorium. At least here in El Paso County, the way it has been applied has been that your landlords are able to take you to court and go through a trial. However, the writ of restitution that you're seeing on the screen, that's not able to be used to remove you from the residence until after the eviction moratorium has expired. But moving into fair housing, this is there at both the federal and the state level. Fair housing laws prohibit discrimination based on race, color, disability, sex, sexual orientation, including transgender status, national origin or ancestry, religion, creed, marital status, and or familial status. There is currently a bill on Governor Polis's desk to add gender identity and gender expression as protected classes to the Fair Housing Act. Now that's at the Colorado level, not at the federal level. There are exceptions to the Fair Housing Act. Those exceptions are for owner-occupied buildings with 4 units or less, single-family housing sold or rented without the use of a broker, housing operated by organizations and private clubs that limit occupancy to members. Just a brief little bit on service animals versus emotional support animals. First of all, service animals are not a pet. They are the same as a nebulizer or an oxygen tank. They can only be a dog or a miniature horse. They are trained to do work or perform tasks, and they are covered by the Americans with Disabilities Act. Emotional support animals are not covered by the Americans with Disabilities Act, but would be subject to fair housing protections. And that's where a reasonable accommodation request would come into effect as a tenant. What is a reasonable accommodation request? That is, for a landlord, it is discrimination to refuse to make reasonable accommodations necessary to afford a person with a disability the equal opportunity to use and enjoy the residence. There is no magic language for a tenant to make this request, but it must be in writing, and it must state what the accommodation is that you are requesting. So you must be specific as to what you are requesting. For example, if we are discussing an emotional support animal, then the reasonable accommodation would be to permit the ESA, given that you do have a disability, and the ESA would be necessary to afford you the equal opportunity to use and enjoy your residence. There's also a sample letter in the materials online for that, for a reasonable accommodation request. And this is the sample letter that you can find online. So at this point, I will open, and you can see my contact information there. If you call and leave me a message to apply or call with a quick question, I will let you know right now that my response is going to be for you to go through the application process itself. To apply for services, you can apply at extension 444. And you can also apply online at coloradolegalservices.org. So at this point, I would, if there are, I will go back to the questions to see, make sure that I have gotten through them.
And Clinton, I also want to remind the folks who are calling in that they can unmute themselves if they have a specific question by pressing *6 on their phone.
So if you're calling in and can't type and have a question, just go ahead and punch in *6 and speak up.
Oops, can you hear me now?
Yes, I can hear you.
Hi, I'm Cindy and I do code enforcement. So thank you very much for that warrant of habitability or warranty of habitability mentioned. And so I just want to clarify, whatever our code is, and we're a home rule city, whatever our code is, that's it. So because I keep getting these calls that the landlord, like you said about replacing the equipment. Yeah, he replaced the stove, he replaced the refrigerator, everything is working. She keeps calling, but the main thing is the heat. Like you said, if it's reasonable heat, and it is, it's one of those old registers, and she's been shown how to use it. I guess you have to like turn the little knob on the bottom, and she just refuses to do that. So there's nothing more I can do for her, right? On a code enforcement end?
I would certainly have to review any prior interactions. That's way, I don't mean to punt, but that is just way too case specific there for me.
Because I've done the inspection with the fire marshal as well, and he doesn't see anything. He's putting it on the tenant. Like if the tenant has any problems, then she needs to take that up with the landlord, not me.
I would.
Which I told her it's a civil case.
I would speak with the city attorney. I would see if you can contact somebody at the city attorney office. Yeah, to talk to them. Since if you're with code enforcement, then that would be who you'd want to talk to about that, to see if what else, if anything, your responsibilities are on the case.
Oh, okay.
That would just be my, that would,
thank you.
That would just be my thought as to, kind of who would be the legal organization that would kind of be above code. And if
awesome.
and Barb, if I'm wrong, tell me.
Yeah, it's a ping pong match between these two, the landlord and the tenant, and they just got me in the middle of it. And I'm just like, would you just settle it yourselves? So, okay.
Well, Cindy, you
And
can
I just
also
have one
share
other
the
question.
legal. I was going to say you can also share some of the legal resources that we've shared here with the tenant if they think they might have a legal case. Yeah,
That's
thank
awesome.
you.
Thank you. I just have one other question about the writ with we have several hotels in town we're trying to get people out of. So even though they get the writ, the owner of the hotel, they have to wait to the end of, I believe it's June right now is the moratorium of eviction. Is that my understanding?
Couple different things there. Yes, the moratorium is set to expire at the end of June. However, whether or not the writ can be executed is going to depend on the basis for the judgment. So if a writ was issued, let's say a writ was issued because somebody had 4 dogs, then that writ can be executed. But if the writ was issued and it was a non-payment case and the tenant has provided the declaration, then that likely cannot be executed at this time.
Okay, perfect. Yeah, no, they're violating our 30-day long-term occupancy code and damages. So, okay, that's awesome. Thank you so much. This was a great meeting.
Good. So we've got a question in the chat regarding the writ denials of rent applications. As far as a right to appeal, so the question is asking, is there a right to appeal the landlord's decision not to rent or lease to the tenant individual? There's not so much yes and no. I'm kind of hedging on that just because the language of appeal. Tenants do have a right to, or applicants do have a right to send that letter indicating that they disagree with the decision. If that's not remedied within the 7 days, then the tenant is, or the applicant is then able to take the landlord to court for a violation of the Rental Application Fairness Act. There is not an opportunity for a refund of the application fee. Just taking that on its own, if the landlord has denied the application and charged an application fee, then there's not an opportunity for a refund because that fee was used to process the application. Kind of going back to the beginning of it, the fee was not a profit to the landlord. That was just to cover the actual costs or anticipated costs of the application processing itself. Another question is, if a renter feels as they are being discriminated against due to their race and their rent keeps getting increased each month, even though their lease states that their rent won't be increased without a 30-day notice. I would certainly advise that individual to apply for services. If it is a month-to-month lease agreement, then there is requirements for, there is a statute that requires a landlord provide advance notice of a rent increase. But if it's unless the contract states it, I would be very leery of rent increases within a lease itself. So I would certainly advise that renter to apply for assistance and make sure to provide their lease as well. If the lease says the tenant is responsible to replace appliances, does that negate the warranty of habitability? No. Your lease can't waive the warranty of habitability. Also, it depends on what kind of appliances we're talking about here. If we're talking about an air conditioner, I don't think that's an issue. I don't think there's really much of an issue there. If we're talking about a refrigerator or a stove or an oven, yes, I do believe that would not be enforceable because those are protected appliances by the warranty of habitability. And unfortunately, that I have a question that another question that is a bit too specific. I would recommend contacting your former attorney. Are there any other questions from anybody online? Just remember, just hit *6 to ask away. I'm just kind of trying to keep up with the questions in the chat. If I've missed any, please let me know. I don't think I have.
Yeah, well, let's maybe leave that open for another minute or two in case folks are typing. And just a reminder throughout, we have a lot of information in the chat now, including some other legal clinic resources where you can call in and request legal advice about a specific situation, even though Clinton is not able to provide that as part of this. So please do follow up with those. One of them, also, thank you so much, Deb Hamilton, for including some of those resources. And she can also help you at the Pikes Peak Library District if there's some library materials that might be able to help answer your question as well. All right. Any other questions?
One just came in that I published.
Yes.
Okay.
What about someone who rents for years without a lease and works for the landlord for rent? Does the renter have eviction rights if they lose the job? Possibly, yes. So, first of all, it sounds like you've had permission from the landlord, so you're not a squatter. All right, let's just knock that out right there. Now, it depends on the relationship here, because if it is employee housing, then the housing is tied to the job. But that, when I'm seeing without a lease, that sounds like it's not employee housing to me. So if this isn't employer provided housing, then yes, you're a tenant and you still have eviction rights if your landlord / boss fires you. Because if it's not employer provided housing, then your boss and your landlord, even though they're the same person, are going to have two different roles. But in employer provided housing, easiest example off the top of my head is seasonal ski employees, in like Breck or Vail or wherever, that get put up in kind of the employee dormitories. If they get fired from the job, they then have 3 days to vacate the residence. If you recall last year around when the pandemic really kind of exploded in Summit County, there was a really nasty headline for Vail Resorts because everybody's job all the seasonal employees got terminated early when they closed the resorts. So they all got 3-day notices to move out of their employer provided housing. So without a lease, I don't think that's employer provided housing, but I would, again, I'm a broken record. I would recommend that you apply because as you can hear me kind of talking through it, there are some further questions that I really wouldn't be able to get into because of how fact specific they would be at that point.
Right. Other questions? Well, it's looking like there might not be any more questions. If someone squeezes one in while we're wrapping up here.
I do see a new question that got published, but again, unfortunately, these are too specific of questions for me to be able to answer in this segment.
Okay. Well, thank you so much, Clinton, for all of that incredible detail and great information. I am going to just share our final thank you slide.
And I will stop sharing. Thank you all so much for attending tonight. And again, if you have any questions, please reach out to Colorado Legal Services.
Thank you. Okay, let me put that up. So we just really want to thank everyone who attended. Thank you again to Clinton Albert, to Deb Hamilton, Britt Kwan, and Patrick Noonan. These are links to a lot of the resources that we mentioned. And again, we will be sharing the slides, and we plan to post the video of this. You can sign up to receive those if you did not already register at any of these links that I'm sharing now. Signing up for the newsletter or at the Justice Center. And I particularly want to point out the Emergency Rental Assistance Program. So funds are now available for renters from Colorado Springs and really throughout Colorado and the country right now, provided through the Colorado Department of Local Affairs. And those are for people who are having trouble being able to pay their rent somehow as a result of the pandemic. So be sure to look into that if that's something that you need help with. Thank you again to all of our speakers, and this is the end of our presentation. And please do let folks know that we have 2 more events like this scheduled, August 24th and November 9th. And again, if you sign up, we'll be sharing those in the future as well. So please let folks know who you know that might be interested, and get in touch with us if you have questions.
Hey, Barb, before you
Yeah?
wrap, there are 2 more questions that snuck in, and they're right above your links in the published column.
Oh, great. Let's look at those.
All right, so looking at those 2 questions, we have, I saw that a landlord with no lease can evict a renter without the moratorium. As indicated earlier in this presentation, the only situation which the moratorium protects against is a case that is brought under a non-payment of rent case. So there are a number of situations where a landlord with or without a lease can evict their tenant. Can an employer be penalized for leasing to someone with intellectual disability? The short answer is maybe. So that's going to have to require a much more in-depth conversation to be able to get a better opinion on that question.
Thank you, Clinton. And again, with all these links, you'll have an opportunity to follow up and find some other legal clinics, and also apply for help with individual situations. We really hope that this has been helpful, and thank you again to everyone. And we're going to go ahead and sign off. Everyone have a good evening, please.